The next case is People versus Pierson. This is also a motion on the application. You each have 15 minutes.
Good morning. May it please the court, Attorney Scott Grable and Attorney Timothy Doman at counsel table for the defendant appellate Raymond Pierson. I obviously rely on my supplemental brief and reply brief on why I strongly believe Raymond Pierson is absolutely entitled to a new trial. I would try to give the following brief commentary, hopefully adding to my briefs. Notwithstanding the prosecutor's comments comparing my client to Rambo, I would just simply say even Rambo is entitled to a fair trial by an impartial judge. The influence of a trial judge, as this court knows, is certainly significant. And once a trial judge has intimated his personal opinion about the defendant's credibility, the jury, frankly, is unlikely to disagree with him or her as the trial court. As I've cited in my brief, numerous cases that how a judge, even not intentionally, can have a profound influence on, obviously, a sitting jury. Our Court of Appeals has held that a trial judge, as we know, should not inform a jury about the nature, existence, and result of a Walker hearing. These cases date back to the 70s. I've cited numerous opinions, and I'm not going to recite to this court because they've read the brief on page 13 and 19 of my supplemental brief. I don't think this court is going to grapple with me on the issue of whether the trial judge should have disclosed anything in the Walker hearing. I don't think that's probably the main premise I have to overcome here, hopefully to be successful. Obviously, in this particular case, which I think is important, and it sort of goes to the court's analysis of whether this is harmless error of disclosing the Walker hearing in the comments, I think you have to be mindful of the fact that the main strategy in this case of Pierson's counsel was to discredit two of the three police officers, Officer Urban and Officer Botha, because if you don't discredit them, that the statements were never made, not that they were voluntary, that they were never made, he's finished. Because basically they're obviously admissions and confessions. He's done. He's done on both charges. So I think you have to sort of look at the judge's dialogue. Although the statement here that this court is focusing on is brief, you still have to be mindful of the defendant's defense because that really is what I think is important. Obviously, it's important to look at the rest of the judge's comments and what I refer to as intemperate comments by the court during the rest of the trial, in my opinion, heavily, obviously the record speaks for itself, towards the defense. I think what that does is, if you will, gives momentum in leading up to the challenge statement that we think deprived Mr. Pierson of improper trial. I think it gives it the context of what's the reasonable juror's mindset of going into that statement. I think looking at the comments of the rest of the record in totality, I think it makes it much more incendiary when you consider that this judge was clearly, in all due respect, it appeared, I'm not saying he was intentionally, but it certainly gave the objective impression he was certainly not on the defense attorney's side or Mr. Pierson's side. Now, whether
Counsel, the issues that the courts below considered were not, it wasn't a general sort of Stevens question, right? It was simply whether the judge erred in the comment the judge made to the lawyers about the Walker hearing. How can we now sort of translate this into a general Stevens issue? That's
a fair question. The appellee raised that in his brief. The court, in their order, and I'm mindful of the language, said, was he deprived of a fair trial? And if there was an error, to what extent was it harmless? If you're deprived of a fair trial, as the court would agree, it can't be harmless. I don't think the language in the order precluded, respectfully, to this court of not addressing Stevens, because if you have an error that's construed as structural, of course it's not harmless. I certainly respectfully didn't feel that the court's language in the order precluded us from arguing Stevens, because Stevens is a form of error. Of course, if you believe there's a Stevens error, of course it's reversible no matter what the rest of the record indicates if it rises to that level.
But we don't normally, in our orders here, open up whole new questions, right? We normally consider questions that the courts below considered and try and figure out whether those courts got them right. So you're kind of asking us to consider a different claim.
I don't think in analyzing, I guess I would simply say this, and I'm not trying to be circuitous, and I apologize if I am. I'm simply indicating in analyzing whether the statement here is harmless, we're indicating, I'm framing it as a structural error, which, again, not to be circuitous, a structural error, of course, could never be harmless. So I don't, in all due respect, don't think I crossed the auspices of what the court did. I'm indicating this error defined as structural using the Stephen tenets, if you will, as authority. The facts, of course, are not consistent. Again, most cases, when you argue Stevens, you're not going to have the same set of facts. As this court is aware, I hope, I have to defend the court's sensibilities by saying Stevens applies, because the error here, to me, should have been analyzed under a Stevens analysis, because I think it was fair game to do that, because I do think that's the impact that it had. I don't think I crossed the bridges. I think it was still fair game, because when the court indicated, is this an unfair trial? Well, if the error is harmless, Mr. Pierson had a fair trial. I think the court is indicating to me, well, the other aspect of harmless error is, absent this being a mistake, disclosing the Walker hearing, assuming this court finds non-structural error, or we're not going to analyze Stevens, do you believe, pardon me for, I don't want to put words in the court, Chief Justice's mouth, pardon me if I do, I think the court wants to analyze, do you have enough on a harmless error, non-structural analysis? I would say I do, but I certainly don't want to, I want to make sure I answer your question without sidestepping it to a different issue.
I was simply trying to point out that I don't think our order opened up brand-new questions for us to consider, and I thought the question here was concerned the court's statement about the Walker hearing. So, turning to that for a moment.
Please.
It's a little different for the court to instruct a lawyer that the court had already made a decision about the Walker hearing than to instruct the jury that in fact a statement was voluntary. Would you agree?
Oh, I would agree in your analysis, and I would simply say this. I think the question predisposes on what the average reasonable juror's thought process. And I say this with the utmost respect. If everybody here or the dissent on the Court of Appeals was on this jury panel, I frankly don't think I would be here, because frankly, the people with your thought process and experience, and I'm not trying to dummy down the jury, I don't mean it like that, but
it was a Washington County jury. I've picked one there. It had 6 PhDs on it.
And I appreciate it. I'm saying that I ask this court not to have the thought process that you would have. I would ask the court to have the thought process of a reasonable jury. I picked a juror, and I won't digress, down the street. I picked a jury about a mile from this court, and they end up going up to this court for a different issue. The reason I mention that is half the jury panel was the gentleman got charged, must be guilty. Now, everybody here would laugh at that premise, but we had to end up kicking 6 people off. The only reason I mention that analogy is simply this. The average reasonable jury, in answering your question, does not think like the people on this court. They're far removed from voluntary versus admissible and those type of...
To the extent they think the average juror thinks about admissibility at all, wouldn't they think that the evidence was admissible simply because it was admitted?
I think the construction of this is simply this. I think the problem with this statement is the admissible statement may perhaps be acceptable, not that I think it was the prudent thing to do, because as you know, you're not supposed to disclose anything in the Walker hearing. I think the following follow-up statement when he said on the record, the trial court, go ahead, it's true. The problem is the word truth, and we could sit here and quibble on what's the objective thought process of the jury. When you say it's true, to me, you're confirming the fact that the statement was made. It happened. I've ruled on it in a prior hearing, and I understand the judge's comments were not as overt as I'm certainly making them. The record speaks for itself, but I don't think it's an unreasonable construction that the implicit meaning, and again, I'm not suggesting the court was trying to do this. I think he was, again, I don't want to call it arrogance. I don't know what it was, but it certainly wasn't proper.
Just so I'm clear, what do you think the judge meant? That was sort of incoherent when I read it, but what did you think the judge meant when he said it's true, specifically?
Well, if you want to ask me to delve quickly into his thought process, I think he meant, I've
Well, you're
conducted a
arguing-
hearing. Don't question my ruling. I think probably he simply meant that, hey, I've ruled the statement voluntary. The problem wasn't what he potentially thought. It's what the jury's construction of what they would view it. And in all due respect, I feel strongly, and sorry to elevate my voice, I think I've had too much caffeine this morning. I think the average juror would construe it as the statement was in fact made by the defendant. And in this case, that pretty much just sunk the case, because the whole strategy was I must discredit Urban, and then if I can't discredit Urban, I'm certainly not going to discredit Baffa. I'm done. In essence, the trial judge, I'm not saying he meant to do it, he improperly influenced the jury and vouched for the credibility of Urban, and that sunk him. That's why I think, and again, not decisive, that's why I think if you ignore Stevens in this, again, it wasn't raised at the Court of Appeals, and I think the majority opinion got it partially right, but they ignored Stevens. I understand that the fact they ignored it, again, I'm still raising it here, and again, if the court doesn't address it, I'll quickly, hopefully, cover why I think it's still a problem. Although this court may find the defense in this case to be respectful, somewhat incredulous by the defendant Pierson, that he's got to negate the statements. If not, he's finished. You may find that an uphill battle and say, well, look, I think that's a tough sell based on the totality of the record. Assuming I conceded that fact, the judge does not, objectively or subjectively or indirectly get to sink the credibility of this. I think what it comes down to is looking at the statements and say, we don't read it the same way you do. But again, I want you to put yourself in a reasonable juror's position. I feel strongly that the judge basically said, look, you made the statement. That's what, again, he didn't mean it that way, but I think that's the way the reasonable juror would interpret this. I practiced before you, and I'm not trying to single you out, Justice Viviano. I just had the pleasure of practicing you in the trial court, and I've watched your objective, stoic manner. These are comments that you never would have made on the bench. I only single you out because I practiced in front of you, and I don't mean to be disingenuous.
You read my mind because I always sort of think through what my approach was as a trial judge, and I am very sensitive to what you started off by saying, which is what a judge says or the judge's mannerisms in front of the jury can be very impactful. In almost every trial that I had, when I would go into the jury room afterward and talk to jurors, they would, even though I tried to be very stoic and not smile or laugh or roll my eyes, they would pick up on anything that you did from the bench when something happened during the trial. They're always looking to the judge to see the judge's reaction. So I'm very sensitive to that argument. I'm not sure necessarily I agree with you in terms of this statement because it seems to me a little incoherent, but even taking the statement in the way that you think the jurors would have taken the statement, what should I think of all the other evidence in this case?
Well, I think all the other evidence, certainly putting aside Stevens as, let's just say, and I'm not conceding it, but let's assume it.
Yeah, let's move past that.
Okay,
just for the
fair enough.
harmlessness assessment.
I think certainly there's other evidence. Now, again, I don't think the officer's testimony was perfect because I think there were issues on credibility of Officer Urban and in all due respect, and Officer Botha. Obviously, there was no physical evidence or fingerprint evidence on the weapons. I'm not going to tell you. I think that this case doesn't have problems from the defendant's standpoint under a harmless error analysis. But if we're going to allow the judge, again, to sink the defense completely by making these comments, if you indulge me and say your interpretation of what a jury would construe these statements, it's true, it's admissible, and how you construe that to be the meaning. If we're going to allow the trial judge to do that in this case or future cases, I'm scared to think. I still think once you impinge upon attacking credibility when it's your main defense, as the court has said in other cases, credibility is a one-on-one credibility contest, and anything could tip the scale of credibility, although not applicable to necessarily these type of cases. I believe the trial judge, whether it be intentional or unintentional, tipped the scale here, and I don't think it could ever be harmless error. Again, in this case, the defendant isn't claiming the statement was voluntary. His whole defense was, I didn't make the statement. If you construe the fact that he made the statement, and the judge is somehow implying that, look, he made the statement, it's true. Obviously, at this point, that, in my opinion, can't be harmless error, whether it's non-structural or just a plain, normal, harmless error versus reversible error situation. And I think one of the court's concerns might be, well, if we rule in your favor, and I'm going to say what Justice Zara said on another case about a month ago, our opinions, no disrespect, spread like wildfire. And I think that was something I saw in the oral argument. This is a very fact-specific case. I'm not suggesting if the court advanced our argument to say, well, we have to make sure that these trial judges, like we've done in 404B cases that I've argued before the court, we got to make sure that they do the right thing, and we're not going to just call it harmless error. If the court was to reverse here, it's going to have to be based on the fact that the defense was specifically based on a credibility tack that the court sort of significantly undermined. I don't think it's going to have precedential value to somehow erode the judge's ability to answer questions and answer things in the future. In this case, you do start with the premise, we all know we shouldn't have mentioned the Walker hearing. It's a question, well, how much harm did it do? I think it did a lot of damage in this case because of the defendant's defense.
Thank you, counsel.
Thank you for your time.
Good morning, may it please the court. My name is Mark Kneisel, representing the plaintiff appellee. 2 years ago this Friday, I was before this court, and one of the results of that case was a new Michigan Court Rule 6.417. I'm suggesting today maybe a result could be a new rule urging, even requiring the delivery of criminal jury instruction 4.1 when the circumstances require, and obviously unless the defendant explicitly objected. But first, the court is considering whether there was error by the trial court, whether the defendant was denied a fair trial, whether the error was harmless. And perhaps more generally, the court is grappling with what to do with the Court of Appeals' published opinions. Of course, I do agree that the court should not entertain a structural error analysis because the court didn't ask about it, also because it's virtually entirely unpreserved, and we're here on collateral review. This court need not overrule or otherwise tinker with the 4 cases in its MOA order. And if this court does something other than deny the application, it could further entrench that precedent. But entrenching that precedent does not, for prospective guidance, does not mean that the defendant here was denied a fair trial. When the jury was deliberating and the jury was considering the plural statements of the defendant that were admitted, and the court stated were admissible in the presence of the jury assuredly was not prioritizing or discounting any one of the statements over any of the others based on what the judge said. Finally, even if there were error, it was absolutely harmless based on the eyewitness testimony, the direct eyewitness testimony, and various pretty compelling circumstantial evidence. Quite frankly, when the deputies found those AK-47 magazines in his car, he was guilty. I mentioned 4.1, jury instruction 4.1. Its applicability is why there can't be a per se or automatic reversal rule. If a future trial court missteps and makes a commentary about voluntariness or even admissibility, depending on where this court falls on that dichotomy, the remedy is an immediate delivery of 4.1 and perhaps a return to 4.1 in the composite instructions at the end of the trial. The remedy would not be an automatic, irreversible mistrial, no matter what everybody wants. We've got to mistry this case because that's a per se error. That just can't be, I think, how the process can run. So therefore, as I said at the outset, if this court wants to speak to the propriety, if not the requirement of a 4.1 instruction, if and when this happens in the future, I think that would be appropriate. This court could do that while otherwise denying this application.
Was there no 4.1 instruction in this case?
There was not.
The reason for that?
Not that I know of.
Defense did not request one?
Correct. At the end of the composite, so as both the, I'm going to say both the writing judges, I guess, from the Court of Appeals pointed out, the regular composite instructions of I'm the judge, I make rulings, you're the jury, was given. But not the 4.1, which is, you've heard evidence that the defendant has made a statement. That was not given. At the end of the composite instructions post-trial, the defense attorney asked for 2 more instructions that were given, but not 4.1. The trial defense attorney was also the appellate attorney on direct review and did not raise that issue. Raised an issue about the Walker hearing, but not the results of the Walker hearing, but not about 4.1. So I think that might be the sole point of agreement between the parties is, yeah, 4.1 would have maybe made this go away a whole lot easier. And if that's the prospective rule, I think that's probably okay. But
How does the failure of the trial court to give 4.1 factor into the harmlessness analysis?
I don't think it factors in whatsoever. I think,
I mean, if the court gave it, surely the argument would be that it mitigated the error to the extent there was an error, right?
correct.
So the absence of it, you sort of have an absence of mitigation, right?
Correct, but that can't inure really to the defendant's benefit because he didn't ask for it. So that's how I think that's still foreclosed in our case. So this is it's a little bit of a sloppy, I guess. The other thing is there's 3 statements. A statement to Deputy Urban, a statement to Deputy Buffa, and a statement to Deputy Toth. So the jury was weighing those 3 statements based on the facts of those statements, not what Judge Shelton said to the lawyers about that. Which is also why I think there should be no bright line rule. I think I've just ducked under the time, or maybe not, but I certainly would invite the court, if there's any questions, would like to discuss this further.
Counsel, how do you respond to brother counsel's question about, the idea that if the judge indicated, hey, that this is true, that can be quite difficult to come back from? How would you address that?
So I think that the context that I take that in is that the judge was addressing the lawyers, and he said, we've already done this, I'm not going to listen to these objections about the Walker hearing. And the defense attorney said, I'll object to that, and that's when the trial judge said, fine, it's true. I think fine, it's true was, it's been settled. It's been settled that these are admissible.
But doesn't that make it a little challenging just because of the fact that now the jury is aware that, for 2 reasons. Number 1, that the judge feels that this is true, but number 2, that now that the jury is aware that the defendant tried to suppress this evidence and tried to suppress this information, doesn't it then make it appear that the defendant's more culpable?
I don't think so because of the fact in this case that there were 3 statements. I think that all this exchange did was put those on an otherwise equal playing level. Now, certainly, the defendant argues that one of those statements is favorable to him, and that's the one he wants to be credible. But that argument was still available to him without respect for the judge saying to the lawyers the tautology of, these 3 statements are coming in. So if there would have been just one fully inculpatory statement given by the defendant in this case, that would have been on thinner ice, I believe. But I think because of the disparate and multiple statements, it's just a wash. That's how I interpret that.
Is it fair to say instruction 4.1 is an instruction available to the defense? It's not an instruction the prosecutor ever asked for, is it?
Probably not.
And in this case, the trial court did give its standard instruction.
Correct.
That the jurors are not, that the judge meant no opinion.
One way or the other.
And any rulings or comments that it made should not be viewed as the court's attempt to influence the jury, right? That instruction was still provided.
Correct.
So is 4.1 necessary?
No.
It was available, but not necessary.
Certainly.
I
And
understand.
the only thing I really think that
When you say not necessary, I mean, it would be given in every trial where a defendant made a statement that comes into evidence, every single time. In fact, in my experience, the prosecutors would have presented the instructions with this instruction in it. I mean, there's no, this is, if it's not considered standard, it is as routine as it gets, is it not?
It is definitely routine. I was frankly surprised that it was not given in this record. And again, but what's weird about it is it wasn't not given over the defendant's objection.
Right.
It was,
I can't
So
describe,
I'm just-
I don't know how things are done in Washtenaw County. I don't know how this happened, but I think we can all agree this shouldn't have happened. This instruction should have been given.
I agree, and as I think about this case and try to answer the question of what is significant about it, what are we going to do with this case for the next 100 times that a trial judge blurts out the statement about the Walker hearing, I think the answer is give 4.1 right away.
We need a court rule
Is-
that
is
says
for-
give applicable instruction.
Is 4.1 only when the trial judge makes a comment, or is 4.1,
Definitely not.
it's available
Cor-
anytime there's a statement from the
Absolutely.
defense
Ab-
that's put into
ab-
evidence?
Absolutely.
Sometimes the defense might not want to emphasize it.
Correct. So that's why I would suggest that if there were, I think the court should just deny the application. This case is kind of all over the place. If the court does want to put a rule out there that would incorporate 4.1, it would still have an exception where if the defense declines it, then the defense gets to decline it. And as Justice Viviano points out, I'm not sure if a defendant declined it, would the prosecutor ever say, I demand that you give 4.1? I think it would probably be pretty asymmetric. But that's how I see this. If this case is going to mean something going forward, that's where I think it would land. I don't think this case needs to mean anything going forward because I think you could just deny the application.
But as I understand it, your view is that the next 100 times this is blurted out by a trial court judge, you believe, in accordance apparently with Judge Boonstra, that nothing should be done.
I disagree with that. I think
Nothing should be done by the court,
I-
the appellate courts.
I agree with Judge Boonstra that there is a difference between admissible and voluntary. I think admissible is a tautology here. But I do also think that if an objection gets made and the parties go up and go, Judge, I know you didn't say voluntary, but I wish you wouldn't have said that. I think the answer is, okay, I'll give 4.1. Sorry, I'll give 4.1. So I have a little bit of a disagreement, a little bit of an agreement there.
And
There's no other question?
4.1 is better than emphasizing or giving out of order or giving twice, giving right after the statement, the standard instruction that the rulings and comments are not evidence?
Well, it's there. I mean, 4.1 is a statement-specific composite instruction, so to speak, if I'm hearing your question.
4.1 to me is an instruction that goes to the jury. You get to decide whether any statement made was made.
Even made.
And if it was voluntary, where the standard instruction, to me, is anything I say as a judge is not evidence, is not something meant to influence you. I simply make rulings of law. You decide the facts.
So-
I see these as separate instructions.
I agree, and I mean, I guess another route would be, I think this would be more deviation from the norm, but that might be okay. Another route would be that we never need 4.1. We already have the general composite instruction that speaks to that. But I don't think that this court is going to jettison 4.1. If it wants to think more about that, it could grant the application, and I could talk about 4.1 for a half hour. I think that 4.1 is probably not going anywhere, and if it's not going anywhere, the result of all this going forward is, hey, judges, if you have a brain hiccup, give 4.1. And that's where I think we should land.
Thank you, counsel.
Thank you.
The case will be submitted.